Assalamualaikum warahmatullahi wabarakatuh. My name is HAAFIZHAH binti ABDUL Rasid. My metric number is 254689. So today I will be presenting about application of equity and trust law in Malaysia, United Kingdom and United States. So now let's go through the historical background and development in UK, Malaysia and also US. Alright. In United Kingdom, during the 20th to 30th century, ownership of land in England was based on a feudal system. Unfortunately, fight in crusade happened within that time. So, people had to pass over their land to be handled and taken care of by someone else during his absence. However, usually when the landowner came back, the caretaker would not return the land ownership back to the owner. It could not be settled by the courts, as England did not recognise the principle of equity at the time. When the real landowner failed in claiming back the land from the courts, they usually made petition to the king. When the matter was referred to the Lord Chancellor, the principle of equity was born and cases were decided in just and equitable way. Since then, the principle of trust was brought in as well, when the Lord Chancellor recognized the legal owner as trustee of the land and the original owner as the beneficiary. When requested, the trustee had to transfer the land back to the beneficiary. Hence, it can be said that the history of trust in UK was developed through the principle of equity. In Malaysia, we hold the federal constitution. Prior to our country's independence, we were under the influence of British as well as it had influenced the laws in Malaysia, directly or indirectly. After independence, federal constitution was adopted, where matters were regulated separately under federalist and statelist. It has been stated that law of trust in Malaysia is regulated by the federal constitution and the state. Matters related to trust are always dealt by the civil courts, even it was arguable between civil court of Sharia. As for Muslim, it is dealt under Waqaf. In United States, law of trust was created by Patrick Henry in 1765. Law of trust in US was known as the pure common law trust. In 1890, issue of trust law was raised when Sherman Antitrust Act was created. America was engaged in civil war and later caused the economy to develop very well through industrialization. Industrialization caused monopolization of business by a few powerful people where they were competing to expand their business market. They would control a variety of industries and at the same time, they also control the prices of products in the market as well. This was where trusts were created. The way the trust worked was that when there were competitors entering the market, the parties that entered into the trust arrangements will decrease the price of products until the competitors left the market, after which the prices will be increased again. This incident indirectly caused barriers to the economy and it prohibited competition in the market as well. And this was the reason why Sherman Antitrust Act came into existence. The Antitrust Act was challenged only when the case of United States against E.G. Knight Company was filed. The case was regarding a sugar trust that controlled 98% of the market of the nation, but still the court rejected the challenge to the trust. Now let's take a look on the legislation which governs in each state. For United Kingdom, there are Trustee Act 2000, Next, we have UK Trust of Land Appointment of Trustee Act 1996 and also UK Perpetuities and Accumulations Act 2009. In Malaysia, we have Trustee Act 1949 and also UK authorities use as references which Civil Law Act 1956. Meanwhile, in the United States, we have Uniform Trust Code 2000 and also Uniform Prudent Investor Act. We will be discussing on duties of trustee, which it concerns the duties of trustee in US and UK. As for United States, it is being mentioned in Title 11, Chapter 7 and Subchapter 1, Section 704 of the United States Code. The duty of care of a trustee is not mentioned, where trustee has a fiduciary duty to make full and frank disclosure when needed to do so, and also the trustee has an administrative duty to make a final report and file the final account with the court and also the United States trustee. Meanwhile, in United Kingdom, it is being stated in UK Trustee Act 1925 and UK Trustee Act 2000. The duty of care of trustee is stated in Part 1 of the Trustee Act 2000. When a trustee is under a duty of care, the trustee ought to exercise such care and skill which is reasonable, and when the trustee under a duty not to claim for remuneration, which is stated in Part 5 of the Trustee Act 2000. In the aspect of remuneration under duties of the trustee, it is not mentioned in United States. Meanwhile, in United Kingdom, it is stated where it can be seen in the case of Craddock against Piper, where the court held that the solicitor who was also a trustee was entitled to claim for the cost of the litigation. As for duties of trustee in Malaysia, it has been provided in Trustees Incorporation Act 1952, which had been revised in 1981. Most of provisions in Malaysia regarding duties of trustee is pari materia with the provision of the UK Trustee Act 1925 and US Code. For example, in Section 9 of Trustees Incorporation Act 1952, it is parallel to the Section 3 of the United Kingdom Trustee Act 1925, whereby all powers conferred on the trustee shall be carried out according to his discretion, but are subject to consent or direction. Similarities between these three countries in relation to the duties of the trustee are duty of loyalty, duty to collect and protect trust assets, duty to identify assets as trust property, duty not to commingle trust funds, duty to delegate, and duty not to delegate. As for the powers of trustee, there are several differences that can be observed between these three countries. In common law, the trustee may appoint a broker or solicitor to do that which in the ordinary course of business, other people will employ brokers and solicitors to do and will not be liable if the broker or solicitor turns out to be dishonest. This can be seen in the case of Spike against Gown, where trustee was not liable to the beneficiary for the loss of the trust funds caused by the brokers dishonestly. In United States, it applies the conventional rule where trustees may hand over administrative responsibilities, but they are not allowed to delegate their discretionary duties. In the new Uniform Trust Code, a trustee may delegate duties and powers that a prudent trustee of comparable skills could properly delegate under the circumstances. In United Kingdom, in making decisions, the trustees should act current with all the relevant facts, consider whether they need expert advice from lawyers, accountants, investment advisors, or other specialists. After considering any expert advice that they think is necessary, the trustees must ensure that they turn their own minds to the question in hand, acting honestly and in good faith. The decision must be theirs and not that of their expert advisors, as trustees are not permitted to delegate their decision-making power except when this is authorized by the trustee. Now, let's take a look on the definition of breach of trust. There is no differences in the definition of breach of trust between the Malaysia, UK, and US jurisdictions. Generally, a breach of trust is defined as an action of a trustee which results in a contravening of his or her duties. It can also be in the form of excess of his or her powers. This can arise whether from the trust instrument itself or whether they arise from obligations imposed by equity. In Section 1001, American Uniform Trust Code provides that a violation by a trustee of a duty the trustee owes to a beneficiary is a breach of trust. A breach of trust may occur by reason of an action or by reason of a failure to act. There are several defenses that can be used by defendant for breach of trust. In UK and Malaysia, a trustee may rely on exclusion clauses to validly exclude liability should there be any act on the part of the trustees that amount to a breach of trust. It can be seen in the case of Armitage against Nurse, which English Court of Appeal stated the position as to whether such exclusion clause stands valid to exclude a trustee from any liability. This case concerned a settlement where a lady was entitled to the remainder of a certain property conditional on her mother's life tenancy. In an action alleging a breach of trust, the trustee relied on the provision in the instrument where it was said that no trustee shall be liable for any loss or damage which may happen to the fund. The court held that an exemption clause may legitimately protect a trustee from gross negligence, but if such exemption is so extensive that it gives the trustee no rights, then there is no trust. In the United States, it has been stated in the Section 1008 of Uniform Trust Code 2000. It provides that a term of a trust relieving a trustee of liability for breach of trust is unenforceable to the extent that when it relieves the trustee of liability for breach of trust committed in bad faith or with reckless indifference to the purposes of the trust or the interests of the beneficiaries, or when it was inserted as the result of an abuse by the trustee of a fiduciary or confidential relationship to the settler. To conclude, U.S. trust law is more restrictive in the effect of exclusion clause compared to the UK trust law. There are several forms of trust which are secret trust, living trust, and also charitable trust. Now let's take a look whether these forms of trust are existing in these three countries. In US, there is no secret trust. The living trust is commonly used, which it is applicable in conventional revocable trust. It is used in the application of tax. Concept differs from UK. In UK, the secret trust may be fully secret or half secret trust. In the case of Blackwell against Blackwell, it is listed down three elements for a valid secret trust, which are intention, communication, and acquiescence. Living trust is not commonly used in UK. As for Malaysia, in the case of Fatma, daughter of Nagananda, and another against Nivedita, daughter of Nagananda, it is referred to English cases to determine whether there was a secret trust. It was stated that in the absence of fraud or special circumstances, the standard of proof required to establish a secret trust was on a balance of probabilities. In the present case, the court held that there was no secret trust but an express trust existed. Now let me explain on the charitable trust in each country. In UK, charities are registered with the Charity Commission for England and Wales. Charitable bodies and members of the public who donate funds for charitable purposes enjoy tax reliefs. In US, a register of charitable organizations is maintained by Attorney General of each state. The donations to the charities in the US can be used for tax exemption if the organization has exemption status from the Internal Revenue Service, which usually refers to non-profit organizations under Section 501, Subsection C, Subsection 3 of United States Internal Revenue Code. Meanwhile, in Malaysia, charitable trust is influenced by English case law and the Charitable Users Act 1601. It is being stated in Schedule 9, List 1 of the Federal List of Federal Constitution, which it excludes Wakaf and Hindu endorsement. Wakafs are there under state list. Charitable endowments made by Muslims are regulated by Islamic law and not following the UK trust law. However, there are criticisms in the application of equity and trust law in UK and US. In UK, the beneficiaries can terminate a trust after the settlor has passed away when everyone has come to an agreement. Thus, the purpose of creating the trust was criticized. Meanwhile, in US, the law gives extensive consideration to the settlor's intent, and so beneficiaries cannot simply change it or terminate it by their agreement or according to their will.